Well, it's a pleasure to meet all of you. And I've actually been to most of those places. And a lot of you are Georgians, so I'm guessing a lot of you are probably going to stay here in Georgia and work with our public schools. And I'm just absolutely delighted that you're going to do that. So why is it that you need to know what I know and what I'm going to talk with you about? A good friend of mine, Carl Glickman, once told me that before you can reasonably expect anybody to learn anything, you're first going to have to persuade them that it's going to make a difference in their life. And that's a pretty reasonable assumption. Something to think about as a teacher, too, when you're teaching those students how to diagram those sentences and that sort of thing. How's that going to make a difference in their life? And if you can't come up with a good answer to that, they're probably not going to pay all that much attention. And please let me know on that one, too, because I've been wondering that for years. But here is why this is going to make a difference for you, and that is knowing the law is about self-preservation. Ignorance of the law can have dire personal and professional consequences for you, and that is career-ending mistakes, fines, or even the possibility of imprisonment. Now, I'm not here to freak you out. That's not what I'm trying to do. I'm here to make sure these things don't happen. Because what I want you to do is to have a long and uneventful career, one in which you can focus on what you want to do, and that is working with kids and doing good things for kids in your community. We don't want to see your name in the paper unless you're getting an award. That's a good thing. But unfortunately, some people don't know where the landmines are, and sometimes they step on those, either under the law or under professional ethics. It's been a couple years ago, but there was a young lady who was one of our graduates, and she was teaching here at an area school district. And like many of us, I'm from the Midwest, so I got to tell you, if you don't drink beer, I'm kind of suspicious of you. But the culture in much of the rural South here is very much that they really don't want you to drink beer. Well, apparently she was on the website, and it looked like she was drinking an alcoholic beverage, and she ends up getting in a lot of trouble with the school district, and you probably know the rest of the story. Well, we don't want to see those things happen. We want to see you have an uneventful career, so that's what I want to talk with you about, both the law and professional ethics. They're both serious things, but the law certainly is the more serious of the two, because the PSC, the Professional Standards Commission, they can't send you to jail. Under the law, that is a possibility. It's not very likely. There are only a few things in your professional capacity that can result in that, and I'll be certain to talk about this. But this isn't just about avoiding bad things. It's also about making sure that you're professionally confident, which is a good thing. And when you know about the law, that can be empowering to you, and it's going to make you more effective as a professional. At some point in your career, you're probably going to have somebody threaten you with a lawsuit. And a lot of times those people have no idea what they're talking about. And if you know what the law is, then you know not to worry about it. But if you don't know what the law is, it can be very intimidating, which is the whole purpose of the threat. So I'm going to talk with you about what the law is so you'll be more professionally confident. And it's also about institutional protection. Those who don't know the law end up putting themselves, their institution, and everyone in it at risk. If you're in a small school district and that school district loses a $3 million judgment against the school district, they're going to be really unhappy with you, because that's $3 million that they could not have used, that they now can't use for other things like books and teacher salaries and that sort of thing. So this is all about preserving yourself, being professionally confident, and also protecting your institution. How is it that you learn the law? Well, I do this a lot, actually, both for higher education and K-12 education. And for the higher education one, I'm not kidding about this, they actually give me 5 minutes to teach a group full of graduate assistants what they need to know about the law. I got to tell you that's impossible, and that's why I put in there. You can't learn everything you need to know about the law and professional ethics in 5 minutes. But we can go over, this is going to, thank goodness we have more than 5 minutes, thank you. But we can go over the basic and most important principles. And I also want to tell you throughout this, this is not, I don't want to give a lecture. Professors are really good at giving long lectures that put people to sleep. That's not my goal. It's already 5 o'clock and we're tired. What I would like for everybody to do is to be interactive. If you have questions at any point, I do want you to jump in. And it's important to remember, this is a highly litigious society that we live in. So you really do need to know this stuff. In fact, it's so litigious, you can see the artifacts of that virtually every place you look. When you're driving your car, take a look at that rear view mirror. It's going to have these little letters on it that says objects are for something further or closer than there. Well, we all kind of know that because the mirror is distorted. But somebody must have had an issue with that, or that wouldn't be on there, right? Even things like on a lawnmower deck, it'll tell you, warning, do not put hands or feet under deck when blade is in motion. Well, we kind of knew that, but apparently somebody didn't also, which leads me to my favorite education law story. And this is absolutely true. There was a student at the University of Illinois who had had too many malt beverages, I think, and he decides he's going to, he looks out the window from the third floor of his dormitory. That's where he lives at. And now there's the parking lot, and he sees his buddies walking across the parking lot, and he just thinks this would be really funny if he moons them. So he does moon them, and in his condition, his balance is impaired, so he ends up falling through the window. And he falls 3 stories down. Well, whose fault is it? Thank goodness he wasn't killed, but he was injured. Whose fault is it? Well, obviously the University of Illinois, right? Well, thank goodness he didn't win that lawsuit, or every one of these windows would have a little sticker that says, warning, do not press butt against glass. That's the kind of world we live in. People are going to do crazy, crazy things like that. And I don't give one of these presentations, particularly with people that are out in practice, where I don't have somebody come up and tell me about some crazy thing that somebody threatened them with, because people are not particularly willing to take responsibility for their own conduct sometimes, and they're looking for somebody else to blame. Well, you don't want to be the person that they blame. You certainly don't want that blame to stick. So what's the remedy to that? Know about the law. So I want to talk with you about essential constitutional principles. I want to talk with you about common law principles. I want to talk with you about essential federal and state laws, and then also the essential principles of professional ethics for you. Okay? Let's talk about constitutional principles first. Everybody that works for government, a government agency, federal, state, or local, is bound by oath to support the Constitution. I was just saying that. Now, what happens if you don't do that? That is a condition of your employment. You're a state agent because you're in compliance with the Constitution. Once you cease to be in compliance with the Constitution, you're no longer a state agent. You can be terminated at that point, and also subject to civil liability, which is monetary damages. Now, before you freak out, in most instances, if you're involved in a lawsuit with your school district, they're probably not after you. They're probably after the school district, which is the deeper pocket. And I got to tell you, when I was your age, what did I have? Mostly student loans. So even if they sued me and won, they weren't going to get a whole lot. Well, still, you do want to know what the constitutional principles are, because you want to respect the law, and you don't want those sorts of problems, and your school district certainly doesn't want them either. So what are these principles of constitutional law? One of them is respect for religious freedom. And that is, while acting in your professional capacity, government agents have to remain neutral concerning religion. Now, I don't want you to misunderstand here. There's a lot of misunderstanding about this First Amendment principle of neutrality concerning religion. A lot of people think that means that it's anti-religious. That's certainly not true. A lot of people think that means that if you want to work for the state, you can't be a religious person. That's not true either. You can most certainly be a religious person. You could be a clergyman on Sunday, and you could be a public school teacher on Monday, and there are people that do that, and they balance it just fine. But what you have to do is that you have a constitutional right as an individual, which you do not give up when you become a public school teacher. You have a constitutional right to your own religious freedom. It's just when you're acting as a teacher in your professional capacity, or administrator, etc., in that situation, you have to be neutral concerning religion. And this is because we don't want a link between religious belief and state power. We don't want this coercive effect of the state to be used against people concerning religion. In many parts of the world, people are killing each other over religion. We have the most religiously diverse nation on the planet, and yet we're not killing each other. You know why that is? Because of the First Amendment. And that is that government power and religious belief are not linked. Religious belief is kept within the private sector, and government power is kept within the public sector. Now, could you ever wear a symbol of your religion when you're acting in your professional capacity? I want to point out to you that this is not an absolute rule. A lot of times they talk about Jefferson's wall of separation between church and state. It is a contextual wall, and that is that it is not absolute. How high the wall between church and state is depends upon the context and the circumstances. Now, I would tell you that that wall is at its very highest when we're talking about a public school. And that's because we have children there that are impressionable, and they're also there under compulsory attendance. And that's why the court is so especially concerned about state officials using religious influence in public schools. But could you wear a symbol of your religion while you're on duty? And I think the answer to that is yes. This is not an absolute separation. If it was an absolute separation, and you were talking to the kids about the Pilgrims, for example, this time of year, and you tell the kids, well, the Pilgrims left Europe on such and such a date, they arrived on such and such a date, and the kids ask, well, why did they come to America? Can't tell you that. That would be absurd, wouldn't it? You can tell them that. They came because of religious belief and religious principle. Well, back to the question of whether you can wear a symbol of your faith. I think the answer to that is yes, but it is dependent upon the circumstances and not appearing to take sides concerning religion excessively. For example, what if you were wearing a 1-inch crucifix or a Star of David, etc.? Is that going to be okay? Yeah, I think that's going to be fine. I don't think any reasonable person is going to believe that you're trying to inculcate religion in their children simply because you happen to be wearing a unobtrusive symbol of your faith. Well, what about a 2-inch crucifix? What about a 3-inch crucifix? What if you come in carrying a crucifix? At some point, and that's one of the problems with these First Amendment issues concerning religious freedom, is that there's not a bright line distinction. We can tell at both extremes. We know something is perfectly fine, and that is the U.S. Supreme Court said in 1963 that it can be argued that one's education is not complete without instruction in the history of religion. Religion is literature, etc. Georgia has a Bible curriculum, and that's perfectly lawful to have that. But it's not taught as religion, it's taught as history or literature, etc. So we don't have a bright line distinction between religion, we instead have a contextual one. Any questions at any point? Please jump in, that's the whole purpose of interaction. If I was just going to lecture, I would have sat in my office and just recorded that and sent it to you. So please go ahead and ask questions at any point. Anything about that? Perfect. Yeah, please. Thank you for asking a question.
Do you extend the logic of that to say political views and expressing those in the classroom?
That's a great question, and it even leads us into the next section here, and that is a respect for free speech. And these are very different. Religion and free speech are both in the First Amendment, but they're very different principles. Religion is kind of like a third rail in the Constitution. Our founders were very concerned about putting together state power and the ability of state officials to coerce concerning religion. But government officials, although they cannot be involved in religion, government officials can certainly be involved in government, right? So it's perfectly lawful for government officials to advocate governance principles and principles of government. So it's a different sort of limitation here. What we do concerning free speech is that we protect people's free speech rights. In fact, Monday I had the wonderful opportunity. Have you ever heard of a lady named Mary Beth Tinker? Anybody ever heard of her before? Anybody in here? Mary Beth Tinker. You may have known what she did. During the Vietnam War, she wore an armband protesting the Vietnam War. Anybody heard of this before? Okay. And she wore it to her school, and she got in big trouble for that. She gets suspended, and she doesn't think that's fair because this is her speech. She's expressing her dissent to war, and the school district says, you can't express dissent to war in our school. So she gets suspended for that. Well, she takes the case all the way to the U.S. Supreme Court, and she wins. And the U.S. Supreme Court says this: it can hardly be argued that either teachers or students shed their constitutional rights at the schoolhouse gate. So because of Mary Beth Tinker, all of us have a guarantee of constitutional rights, whether you be a teacher, and that's teachers also. You have a right to express your opinion. Now, I would tell you, just being very practical, I think your right to express your opinion is greater after you're tenured, to be honest with you. Practically, I think that's true, but it doesn't mean you don't have that right when you're not tenured. You most certainly do because of Mary Beth Tinker. There were real questions about that prior to the Tinker case in the 1960s, and that is, were public schools nurseries for the democracy where we're going to encourage and protect freedom of speech so that these children can grow up to be active citizens, or were public schools more like military institutions? Anybody ever served in the military? You have constitutional rights in the military, but they're not the same thing. They are severely curtailed because You're involved in a very different sort of activity. Well, the court says in the Tinker case, it's the former, and that is that our public schools are nurseries of the democracy. We're going to make sure we protect students and teachers' rights to freedom of speech. Now, your question was concerning expression of opinions about government and that sort of thing. Well, how are we actually going to deal with that in the classroom? Everybody in that school is going to have free speech rights, and it can hardly be argued that they shed those at the schoolhouse gate, the court tells us, right? But you also got to teach a class, don't you? What if somebody wants to express their political beliefs during your lesson when you're teaching about diagramming sentences or whatever it is you're teaching? What if somebody wants to do that? What can you do? Well, and this is mailed to you all, so you can always apply reasonable, TPM stands for time, place, and manner restrictions to individual speech. But you don't want to infringe upon simply individual political or religious speech. So I can always tell this, if a student's interrupting my lesson, I can always say, excuse me, but why don't you talk about that after class or between classes? You know, I'll be happy to talk with you about that after class, but right now I'm busy teaching and I don't want you to disrupt my lesson. And that's perfectly lawful for you to do that. Now, what if I only told people that expressed Republican views, or people that express Democratic views, or liberal or conservative, or et cetera, et cetera? What if I'm taking sides in this political debate? Is that going to be lawful? No, I'm not supposed to be doing that. That's protected by free speech. So time, place, and manner restrictions are neutral concerning the content of speech. It's just that we don't want you talking and disrupting at this particular time. Does that make sense to you? And you certainly have the right, and actually I think you have the responsibility to do that as a teacher. You can't have your classroom chaotic and disrupted. There's a time for you to talk. There's a time for everybody to talk. Well, what if somebody is saying things that they're representing as political speech, but actually they also include obscenities, for example? Not permissible, right? You can certainly express your opinion, but you cannot, you don't get to curse in the public school, even if you call it political speech, right? Well, what if they're not doing that, but they're saying things that are really inflammatory or disrespectful? Are you going to be able to do something about that? You can and should punish anything that's punishable under your school code of conduct. It's not protected speech when it's prohibited by the school code of conduct. Does that make sense to you? So if somebody's threatening other people, if somebody is being disruptive, you can always apply reasonable time, place, and manner restrictions. The time was not now, the place is this is not the place, and the manner is we expect everybody to be respectful when they're expressing their opinion. There's really nothing you can't say concerning politics or religion and not say it in a respectful manner. And in fact, political debate is promoted by respectful discussions, and it's actually interrupted by disrespectful discussions. The Fourth Amendment, we're actually blowing through the Constitution pretty quick here. The Fourth Amendment is about reasonable expectations of privacy. I'm a little concerned about that. I don't know whether anybody else is, about where are the limits to that. You know, the NSA surveillance and that sort of thing. And we can talk about that if you want, and the effect on people, and whether it's consistent with the Fourth Amendment. But let me go ahead and just tell you what the basic rules are concerning a reasonable expectation of privacy. And that is that it's guaranteed to you by the Constitution. And in fact, all free people should have a reasonable expectation of privacy. There should be some clear limits as to what the government can and cannot do concerning invasion of your privacy. We don't want to live in a society like in East Germany back during the Cold War, where we had Stasi agents who were hiding up in the ceiling tiles in your home. And people really did things like that. After the Berlin Wall fell, we found out that about half of the society was actively involved in spying upon the other half, that you had family members, children, parents, spouses, who were actively involved in spying on their own family members and reporting that to the government. That is not a healthy society. That's not a society that you don't want to live in. That's not even a society that's sustainable. We want a society in which people have the dignity of having a reasonable expectation of privacy and clear limitations upon government. Now, sometimes government does have a reason to search for things and to seize things. And your government, if you're a public school teacher. What if you believe that somebody has contraband on their person? Well, I'll tell you what I would do as a teacher. The first thing I'm going to do is report what I know to a school administrator, because I don't need that. You know, the administrators hopefully are well trained in how to conduct a lawful search, and they should have, certainly if they've had my class, they're well trained in that, and they should know how to do a lawful search. So whenever possible, I would simply report what I knew. But there are going to be times where the problem comes to you. I told you I wasn't going to move around, and I'll try not to move around very much. But what if, for example, well, I'll start with this. Do I have a reasonable expectation of privacy in the contents of this bag? And the answer is yes. Okay. Under the Fourth Amendment, it says that your person is protected, your houses are protected, and your papers and effects are protected. Well, these are my papers and effects under the Constitution, so I have a reasonable expectation of privacy in these. Certainly when I'm carrying them around, we know that they're mine. What if I leave this here? Do I still have a reasonable expectation of privacy? And the answer is yes, because I'm still right here with it. We know who it belongs to. What if I leave the room? Do I still have a reasonable expectation of privacy? Yeah, because all of you know who it belongs to, right? So my right of privacy extends to all of you knowing that this thing belongs to me. What if we all leave the room? Well, now we got a bag sitting there all by itself, and a government official, a campus police officer, for example, or an administrator, could come in and say, well, that's odd. There's a bag sitting there all by itself. Maybe it's lost, and I need to return it to the owner. Maybe it's stolen. Maybe there's something dangerous in it, like a bomb. So how we know whether there's a reasonable expectation of privacy is we balance the individual's right against government's legitimate need to search. As government's legitimate needs to search increases, it may at some point outweigh the individual's reasonable expectation of privacy. And there are some circumstances where you don't have any reasonable expectation of privacy. I was telling, I can't remember, Ron. Yeah, I was telling Ron earlier. He can videotape me, and any of you can videotape me, and you don't even have to tell me. In this state, this is a one-party state concerning those sorts of recordings, and all that has to happen is one party to the conversation has to consent, and that can be it. And that's a heads up for everybody. Anybody in the state can record you at any time. So and even if they tell you they're not going to. I have a friend who works for the GBI, and he'll do this. You know, he'll be interviewing a suspect, and he'll tell that person, do you mind if I record you? I got this little recorder here. Would you mind if I record you? And the person, oh, no, I don't want to be recorded. Okay, I won't record you. Guess what he's doing? He doesn't need their permission to record. And I want you to have that heads up too. Don't say or do things in your professional capacity that you don't want other people recording, because a parent or an administrator or a colleague or a student, any of those people, we live in an age now where people may actually record those things. So I just want to give you a heads up so you don't embarrass yourself or worse in a situation like that. Well, what's another situation where you might not have a reasonable expectation of privacy? What if I have this bag unzipped like this, okay? Bag's unzipped. And you come by, or campus police officer, or anybody comes by, and they look in there and they see there's a bong in there. Problem? Big problem. Because anything that's left in plain view is not protected by any reasonable expectation of privacy too. Now, why is that going to matter to you? If you've got students that are looking at inappropriate materials and you happen to see that on their computer screen or whatever, that is not protected by any reasonable expectation of privacy. If you see students that are engaged in activities that indicate that they're cheating, you may have to, at that point you may have sufficient cause in order to go further and find out whether there's evidence upon that electronic device of cheating. Now, what you don't want to do is go beyond the scope of your reasonable suspicion. And that is that if I think that you were cheating right now in my class, I get to check things that may have been recorded or sent right now. I don't get to go on a fishing expedition over the last 6 months. You see what I'm saying? Uh-huh.
About the recording thing, so why is it that schools obtain permission slips for their students to be recorded or videotaped?
Children are different. We have special concerns about children, and there are issues, for example, concerning safety. We may have somebody who's, we're trying to make sure that they're not discovered by a parent who does not have custody and might kidnap the child, that sort of thing. So there are special concerns regarding children. But in a situation like that where we all have adults, we've all consented to be in this room, and our remedy is simply not to be in this room. But it is different concerning children. But children don't have a reasonable expectation of privacy when they're out on the street. There's also FERPA, the Family Education Rights Privacy Act, which specially protects the rights of students in educational institutions.
Kind of a follow-up to that, I know in the school that we're in,
Oops.
they will do surprise checks of lockers. They'll come through with drug dogs
Mhm.
down the hall.
Sure.
They actually will, if they'll look in people's car. As a matter of fact, I just heard that stated this week,
Mhm.
that if your car is in our parking lot, we have the right to search it. If you're on school property in our parking lot and we want to go into your car, we can.
Well, here's what I would say. The first one there, the lockers, there's no question about that. In fact, take a look at every one of your handbooks. And I also want to tell you, I think I have a note on it later, but actually read your student code of conduct and actually read your school policies. It isn't going to take you that long, seriously. You can sit down in an hour or two and get through both of those, probably less than that. And then you'll actually know what the rules are. But what you would find in that student code of conduct is a clause in there that's going to say there is no reasonable expectation of privacy in public school lockers. These are the property of the school district. So the people use those lockers, including teachers if they're using lockers, you use that with an expectation that anything you put in there, there is no reasonable expectation of privacy. So the lockers, not protected. What about the dogs? The dogs are simply, remember when I told you about nothing being protected when it's in plain view? If you want to keep something private, you have to have it not out in plain view. Nothing is protected when it's in plain view. So what's that have to do with dogs? Well, they don't use their eyes. They use their nose. So it's plain smell. And dogs can walk around and smell anything they want to smell as long as they're in a common area. Now, they don't get to come into your dormitory room unless there is sufficient cause for doing so. And university's going to have to go to a magistrate and get sufficient cause for that. But if they're just walking up and down the hallways in the school, that's perfectly fine. We do have a limitation on that, though, from the Fifth Circuit Court of Appeals, which used to be your circuit, now you're the 11th. But they said that the dogs cannot poke and jab their noses into the students. So you need to be real careful if you're a school official that those dogs don't touch the students, or it's going to be an unconstitutional search. Now, why did the Fifth Circuit draw the constitutional line at a dog's nose? Well, they had to draw it someplace. So the dog can smell things, but they're not allowed to touch people. Now, the other one was about the cars. Now we're getting in some tricky area, and that is that I think, I would argue that the cars are more like the papers and effects. Now, if something is in plain view in the car, like somebody walks by and they see pills up on the dashboard or on the seat, or they see a weapon on the floorboard or whatever, that's in plain view if they can see it through the window. And you can be really nosy looking through the window too. You don't have to be polite. But if you can see it as a state official without entering the vehicle, I think it's in plain view and not protected at that point. What if you can't see it? What if you have to open a trunk, or you have to open a glove compartment, or if you search under the seat, or that sort of thing? If it's a public school official, I think they're going to have at least reasonable suspicion at that point. They're not going to have to have probable cause, which a police officer would have to have, which is a higher standard. But you're going to have to be able to articulate some reasonable basis for why I need to search that car. Although I can always ask the student, can I see what's in your trunk? And if they show me, and they open the trunk, and there's a loaded rifle in there, they're going to have a problem. You can always ask somebody to show you something, or give, if it's a search by consent, it's not prohibited by the Fourth Amendment. And if you guys want to know more about that, there's quite a bit more in both of those books. They're going to be left in the department. I want to talk with you about due process and equal protection also. Due process is about making sure that we don't take away people's life, liberty, or property without giving them a sufficient opportunity for notice about what the law is, what's required, and an opportunity for them to be heard. And this is one of the ways that school districts get in trouble all the time, is they punish people without telling them what the rules are adequately, or they punish people without giving them an opportunity to say why they did something. I just saw in Florida, what was it, the 7th or 8th largest school district in the nation has abandoned their zero tolerance policy. You know, these zero tolerance policies where if they see anything they deem to be a weapon, they're going to punish that person as if they had some evil intent to use it. Those are being abandoned. Thank goodness, it's about time. There's a big difference between somebody who brings in a loaded weapon with the intent to use it. And this young lady who was helping her mother move over the weekend, and she accidentally dropped a steak knife out of one of the boxes when they were moving. And school officials sees it through the window, so it was lawful, but then they want to punish her as if she was a felon. I don't think that's reasonable. And I think that's a really wise move, and I think that's the direction we're going to go. I think we need to get back to the place where we actually respect due process of law, and that is that we can punish people when they do things that are prohibited, but you got to have fair rules, and you got to make sure they have a fair opportunity to know what the rules are. Anybody ever seen Animal House before? Anybody willing to admit you've seen Animal House before? Dean Wormer puts that fraternity on double secret probation. You can't really do that. You can't put people on double secret probation. You got to tell them, if you're going to take away their rights, you're going to put them on probation. You got to tell them why it is you're doing it. You got to give them a fair opportunity to respond. The Equal Protection Clause is about making sure that people are treated as individuals and not as members of a group. So those are the essential principles of the Constitution. And that's a big one. It comes about after the U.S. Civil War. And it was in large part to protect former slaves from discrimination, but it is about protecting everybody from discrimination and making sure that you're not treated as a member of a group. That is, as a male or a female, or as a minority member concerning race or religion, or et cetera, et cetera, et cetera. You have a right to be treated as an individual. And you have a right to be treated equally unless government can show that there's a valid reason for treating you differently. Well, sometimes there are valid reasons for treating people differently. For example, you're going to have different due process rights if you're tenured than you're going to have if you're not tenured. And the reason for that is that you've got a different sort of contract. And that would not be a violation of equal protection. Common law principles. I want to tell you about contract law. One of the first things that you're going to do is you're going to sign a contract. You're going to sign that paper that says you swear to uphold the Constitution, then you're going to sign a contract. A contract is simply a legally enforceable agreement, and it's a written notice of that agreement. I do want to give you a heads up when you take a look at this document, and please do. There's a complete copy in here of the PSC Code of Conduct. And when you take a look at that, one of the principles you're going to find is it prohibits an abandonment of contract. Once you sign a contract with a school district, you are ethically bound to perform the duties under that contract. Now, I want to tell you, though, that reality is that sometimes that can't happen. And the PSC recognizes that within the code itself. And there are also ways, if you behave reasonably and you're cooperative with school officials, that you can make sure this is not a problem for you. Let me give you a more concrete example. Let's say that you've signed a contract to perform, you're going to be a teacher in the school district, you're going to teach 6th grade in that school district next year, and you end up getting sick. Can they force you to teach, or could they end up filing a complaint with the PSC? And the answer is no, because it becomes impossible for you to teach there. And you're going to be released from the contract in that instance. You do want to notify them and give them evidence of what the problem is, but they're not going to be able to take away your teaching certificate because you couldn't perform the duties, because you could not perform those duties. Well, what if you move? What if you end up, now some school districts have policies that if you move X number of miles from the school district, they will release you from your contract. So you want to see what it is their policy is. What if you get a better job? And that happens too. There's this sort of domino effect with jobs, and that is there'll be a job opening here, and it's that person ends up leaving, and then the one person goes, well, they just vacated another job, right? And that may be your dream job, but it doesn't happen until you've already signed the contract with the other district. What you want to do in an instance like that is you want to go to the school administrators as soon as possible and explain to them what happened and ask to be released from your contract. And if they're reasonable people and you've been reasonable with them, that is, don't wait until the last minute before school starts. As soon as you know that you're not going to perform the contract, get a hold of them. So they can, this is all about protecting children's right to have a teacher in that classroom. When school starts, we want a teacher in that classroom. And we want some continuity in instruction too. But if you can get with the administrator as soon as you can and tell them that you're going to take a position in another school district and try to help them, particularly if you're a special ed teacher, a math teacher, science teacher, you know somebody who'd like a job there, who's well qualified, maybe even give them a tip about who would be a great teacher for that, and they're going to be appreciative. If you can get them to agree to release you from the contract, you don't have a problem with the PSC. If you don't get them to agree, you have a problem, and you might lose your certificate, your teaching certificate, and then you can't teach the other place anyways. Well, tort law is all about doing what a reasonable person would do under the circumstances. And a reasonable person, for example, as a teacher, acts in loco parentis, in place of the parent. Essentially, your duty is you're supposed to protect the health and safety of that child as if that were your child when they're in your classroom. If you see something that's dangerous, you see something that might harm them, you're not going to be able to prevent everything from happening. I remember when I was in public school, in middle school, our teacher went on, I think it must have been 2 or 3 days, it seemed like that at least, about safety rules concerning the power equipment. And so finally we get to use the power equipment, and the first thing that happened is one of the students went over there and sawed off a finger. Was that the teacher's fault? And the answer was no. He'd done everything a reasonable person could do concerning safety, and this kid simply didn't listen, and he ends up causing his own injury. Tort law is about making sure that everybody has a duty to be responsible. Now, most of you are responsible anyway. You're going to do the right thing. Not everybody. There's some people that are going to do what they can get away with. And tort law is especially for them. We're going to make sure that if they don't act as a reasonable person and refrigerate food if they run a restaurant, for example, if they don't act as a reasonable person and they know there's something dangerous on their porch and they don't fix it when they know trick-or-treaters are coming, you see what I'm saying? There should be some consequence for that, because if we don't do that, we have a more dangerous society. Well, essential federal and state laws, FERPA, the Family Education Rights Privacy Act, I'm going to try to wrap this up so we can maybe ask some questions. The Family Education Rights Privacy Act is going to essentially do 2 things. It's going to protect your right as a student to access your educational records. So this file that everybody always talks about, your permanent record, it shouldn't be mysterious. You have an opportunity to look at that record and make sure there's nothing in there that's inaccurate if you choose to do that. Now that right actually is going to be exercised through the parent when we're talking about children in public schools. Once anybody gets into an institution of higher education, though, the right then transfers to the student. So if you're wondering whether your parents have a right to your educational records, the answer is no. That is derivative only when it's a minor involved. Right now, you have the exclusive right to that. You don't have to show your parents if you don't want to. It also prohibits the institution itself from sharing that information with third parties without your permission. Now, there are some exceptions to that. Things that are directory information, name, that sort of thing. Those things can be listed in phone books, etc., without asking you whether those can be listed. Although if somebody has a real concern, if you're in the witness protection program, and I'm not kidding about that, that does happen, you may not want your name listed, etc., etc. And you can work with the institution on that. But, and law enforcement agents can pretty much get access to those records anytime they can show that they have legitimate cause to get those. The IDEA, Section 504 in the Americans with Disabilities Act. That's all about protecting people with disabilities from discrimination based upon a handicapping condition. It's about making sure that we provide a free, appropriate public education for children that are eligible. It's about making sure that everybody, employees and students, is not discriminated against if they have a handicap. And if you as a teacher, hearing impairment, vision impairment, mobility impairment, whatever that is, a reasonable accommodation is required from the institution. If somebody has an impairment that is so severe that they cannot perform the necessary duties, though, they're not otherwise qualified at that point. There have been, for example, elementary school teachers, if they went blind or if they were blind. In an elementary school setting, it's probably important to make sure that we have some visual surveillance of students to make sure they're not doing dangerous things. If you're in higher education, that's not going to be a problem. I'm pretty sure that Amy and I both could close our eyes for the remainder of the time here, and nothing really bad's going to happen, right? So we can talk more about that if you want. Copyright law, it's about protecting the rights of authors and publishers, because if you don't protect their monetary rights, what happens is they'll quit making the works, and then that hurts all of us. If there's no benefit to producing works that are under copyright, people stop making them. There's no incentive to do that. So our Constitution creates a right for a power for Congress to protect copyrights, and it goes all the way back that far. But I want to tell you that you have a right to fair use, fair educational use. If there were some materials in either one of these books, for example, a table or a chart or something like that, that you thought was particularly useful for your students, you could certainly share that with your students, so long as it was not so extensive that it becomes a substitute for purchasing the materials. Mandatory reporting laws, I want to give you a heads up on this one because this is one of the ones that can land you in jail if you don't follow this. And that is that everybody in this room, when you become a professional working with children, is going to have a duty to report suspected abuse or neglect of children. That's because that's what adults do. Adults protect children. Children cannot protect themselves. They rely upon us when they need help. They don't know help's available. Sometimes they don't even know what's happening to them is wrong or abnormal. They need to have an adult step up and make sure that they're protected. And all 50 states now have laws that enforce that duty, because there are some people that wouldn't do it, unfortunately. They would ignore the abuse, and we don't want that to happen. We want children to be protected. I want to give those of you that are in higher education a heads up that the General Assembly last year changed this statute to also include persons that are in higher education, and that's new. So I have a duty to report suspected abuse and neglect now, and so does Amy. And that's because, I think, in large part because of what happened at Penn State University, that we had people that were ignoring that. So the law now in Georgia is, it's a much more extensive group of people that have to report suspected abuse and neglect. If somebody shows up in your classroom with illegal drugs or a weapon, you don't decide whether you're going to report that. That gets reported to the school administrator and or to law enforcement. And the General Assembly's already decided that for you. If you don't do that, you're at risk of being in violation of the statute and possibly losing your job or your certificate. You don't want to do that. The kid needs to not bring a weapon to school. The kid needs to not bring drugs to school. Designated student crimes, you have to report a serious assault or sexual offenses. Those are not optional. And I also put down a note there that professional ethics and school policy is going to require you to report academic and professional misconduct. You have a duty under the PSC Code of Ethics to report misconduct by your peers. You don't get to just ignore that. And you want to make sure you do that because you might lose your certificate if you ignore misconduct by your peers. And that's an important thing. We don't want people to simply ignore professionals not doing what professionals should do. So there you go. And I wanted to talk with you a little bit about learning more. I actually sent around a handout on that, opportunities for you to learn more, and that is that there are books available. There are also classes available. We now have a class available for undergraduates too, and it's listed on there. It's going to be offered in spring, and it happens to be online, and it's asynchronous, and the reason we did it like that is so that it would not conflict with other courses. We wanted anybody who wanted to take it to have an option to take it. And what you do in that class is you learn more thoroughly what the law and professional ethics require. And then we have a series of, they're really quite, I know you don't hear people saying exams are fun, but honestly, the students actually find them pretty fun and interesting. Case scenarios, like this happened. Who's most likely to prevail in this circumstance? So I certainly want to encourage you, if you have an opportunity to do that, please do consider it. We would really welcome you. And I think it would be a great opportunity for you to learn what the law is. We don't need more lawyers, but I have had people take the class and end up going to law school too. In fact, that's what I did. I took an education law class and ended up going to law school. Any questions? But yeah, please.
If a student writes in their essay about doing criminal activities such as dealing drugs, but they're already on probation for it, do you have, is that considered harm to the student? Like, is that a moment where you'd be a mandated reporter if they're writing essays about dealing, or is that not considered in the...
When in doubt, I'm going to report. I mean, you really want to protect yourself. You put a lot of money into your education and a lot of time, and that certificate is incredibly valuable to you. You're not going to get paid as much as I think you should get paid. If I were the governor, which I'm never going to be, I would make teacher pay a priority, because I can't think of anything. I think that's the most important thing that we do is educate our children. But even at what you will get, you're going to be making well in excess of $1 million in your career. I don't think there's any question about that when you look at salary and benefits. So That's an incredibly valuable resource, your teaching certificate. You need to protect that. So when in doubt, I would go ahead and report something. If I'm reading an essay and I see in that evidence of abuse or neglect or evidence of criminal activity, I'm going to report that to the school official. And at least I've covered myself at that point. And we may be able to, if it's legitimate, if it really is something. First of all, I cannot imagine people doing things that stupid, but they do. In fact, people will walk up to a police officer and tell them they have drugs. I don't know why they do that, but people do things like that. And people might put in sort of a, if it's a diary type thing, you know, maybe they do put something in there that is problematic. I would report when in doubt. Somebody else has a question.
Kind of going off that, what if they, in a similar case where they're writing a journal or they're writing a poem or whatever, and it's a past experience, like they specifically say it happened in the past, or they had maybe suicidal thoughts, or they had kind of abuse in the past. Is that still something that you would?
I would make sure a counselor and or a school administrator know about it. And if it's suspected abuse, child abuse, for example, sexual abuse, there's no statute of limitations on that. That's still a crime, even if it's been some time ago. So those things are criminal activities, and I would definitely report that. I think, again, what you want to do is when in doubt, go ahead and report it. And school administrators, they've had to take a course in school law where they don't get a certificate in the state. That's required. So they should have had training in this area. Counselors know how to deal with students that may have mental or emotional challenges. What we don't want to happen is for somebody to end up harming themselves or somebody else. And then, first of all, that if we can prevent it, that's the most important thing, is we protect safety and we prevent harm. But the other issue we've got is we've got a document that says those things. We've also got evidence that maybe the school district was negligent in not dealing with it. There's a case called Tarasoff versus Board of Regents, in which a counselor was involved in therapy sessions with a person who kept expressing extreme anger against a particular individual. Now, if they were just angry in general, I don't know what you do about that. But this was anger directed at a particular individual, and this evolves into threats against the particular individual, and the counselor just sits there and dutifully records it. Well, the guy shows up at her door and kills her. And now we've got a dead young woman, and we've got extensive records about threats to this dead young woman. And the courts in California said there's a duty to report that to the individual, at least so that they can protect themselves. She needs to know when this person knocks on her door, do not open the door. She needs to know so she can go to law enforcement and get a restraining order or et cetera, to protect herself. She's completely blindsided because these government officials did not report these threats against her specifically. Any questions about anything else? Yeah, one more.
What if you make, let's say you have suspicion of some sort of abuse, maybe a bruise that's been repeatedly on someone's arm, and you report that, it's found to be unfounded, and the parents or the guardians decide to pursue legal action against you for false accusation.
That's a great question. And this is why I don't want you to be afraid to read these provisions and these statutes yourself, and that's why they're certainly included in this book. This is the Georgia Education Law book, but you don't have to get them through there. You can go online and look at the Georgia Mandatory Reporting Statute. When you looked at that, you would find a provision in there that addresses exactly what you're talking about. It's good faith immunity for reporting. And that is as long as you made that report in good faith, and that is that you did not do it for the purpose of harming somebody. If you make a false complaint and you do it for the purpose of harming somebody, you're not protected and they can sue you and they'll probably win. And they probably should, right? If somebody's using this in sort of a predatory fashion. But as long as you've made a good faith report, you have immunity from civil suit or criminal prosecution under Georgia law. And that's an important thing to know. I want everybody, if you don't walk out of this room with anything, I want you to have the knowledge that you can look this stuff up for yourself. It's on the internet, every statute, every one of the cases that I talked about, all that stuff is available for you free on the internet. And there are lots of good resources for you. Professional organizations a lot of time have good resources for you. I want to give you one caution just so nobody misunderstands. I am a lawyer, but I'm not here giving you legal advice. That's to protect me. And also the university. But I want you throughout your career to be empowered to seek the answers to your own law-related questions. When in doubt, do contact a lawyer, because there are some things, there's a saying that somebody who represents themselves in a court of law has a fool for a client and an incompetent for an attorney. You know, there are times when you need a lawyer, but a lot of times that's not going to be an option. If you needed to know the answer to that question, for example, you could simply go to the statute, and within a matter of minutes, you'd run across the clause about good faith immunity. Then you'd be 100% confident. I can report this. I'm not 100% sure, but I have a reasonable suspicion. The statute is not about being 100% certain. It's about, in fact, the state wants too many reports, not too few. Does that make sense? We'd rather have claims that turn out not to be true than have people not report things when children are in danger. So the statute is intentionally structured. You're required to report when you have a reasonable suspicion. It's not knowing, it's that a reasonable person would suspect. Does that make sense? Anything else?
When talking about the neutrality of religion, like in one of my classes, I'm student teaching right now, and my mentor teacher uses some stuff. We go over like biblical allusions and stuff like that, but we don't touch upon any other major religion. So is that fine? Because he's not saying you should believe this. He's just basically like using Bible as literature, but we don't talk about any other religion.
Yeah, I think that's fine. In fact, the state of Georgia has actually adopted a Bible curriculum, and it's a Bible curriculum. It's not, you know, on various other world religions. It is a Bible curriculum. And somebody could make an argument that they've taken sides in a religious dispute, and to a certain degree, that would be right, probably.
Yeah.
But it's not the sort of thing that they could have adopted another book. If they wanted to have the Quran or the Torah or any other religious book, they certainly could have. It's just this is the one we're teaching. You know, you can't teach all of them at once.
Yeah.
That just, it isn't reasonable. Can I get an amen? That's the problem. You know, you want to make sure that you're teaching it in such a way that it's not religious in nature. If you're teaching about the Bible and it is about the Bible as history or literature, etc., it's going to be just fine. Huh?
The example you had with people who, I knew someone who was a pastor on Sunday and taught throughout the week.
So
And his students knew he was a pastor. Hypothetically, if his students had come, hey, I want to come to church on Sunday, and he would say after school, yeah, sure. You know, is that an issue when he's using like his teacher role to have more people come to his congregation?
If that is in fact what he's doing, that's a problem.
Right.
But he's going to tell you that's not what I'm doing.
Yeah.
He's going to tell you that they just happen to know I'm a minister, and I told him, yeah, I'll see you on Sunday. I'm being professional, and that is that I'll talk with you about religion on Sunday.
Okay.
And now, if he is engaged in religious activities while he's supposed to be engaged in his professional duties, that would be a problem. If you are a clergyman and you're also a public official, it does require some careful drawing about professional boundaries. But I knew someone that did that also, and it was perfectly professional. He could be a Methodist minister on Sunday, and he could show up on Monday and be an official for the state of Georgia, and he treated everybody the same. It didn't matter what their religious faith was.
So I had a student come after school one day, and she came in, she sat down, and she just told our mentor teacher, I need God. Like, that's what she said. And my mentor teacher just kind of laughed and said, okay, well, you know, I can recommend some places for you to go, but I can't say much more than that. And that's why I'm thinking about this. I was just wondering if he said more in an off period, would he have gotten in trouble if he had said more than that?
Well, quite candidly, somebody's got to complain. That's the first thing that has to happen. But keep in mind, somebody can complain. They can make a call or an email to the American Civil Liberties Union pretty quickly. So you want to make sure that you're behaving appropriately under the Constitution. Specifically on that one, if somebody asked me that question, I'd probably say, you might want to talk to your parents about that. That'd be the first thing, because I think that's who's primarily responsible for religious guidance and that sort of thing. You might want to talk to your parents about that. If they said, I can't talk to my parents about that, you might want to talk to the counselor about that. I'm going to keep passing them up. That's what it's like, because I don't want to be involved in religious counseling, and it's not my role. That's not why I'm hired there. But I do think that there are kids who they're struggling with just the challenges of being a young person. And that can be an important part of their life, but that's up to them. It's not up to me as a state official.
How do you bring in like teacher sponsors of religious clubs and stuff like that? Because if it's before and after school, then to me it's doing the same thing.
Excellent question, and Congress dealt with that one. And they passed a statute called the Equal Access Act. And you can look it up really easily, just go to the internet, Google or whatever, and put in Equal Access Act, and you'll pull up this federal statute, and you can see exactly what it requires. But essentially it does this. It's about protecting freedom of speech and drawing appropriate boundaries between state officials and people's private religious expression. And on that particular one, it says that, first of all, you're going to have an adult present anytime we have kids meeting in the school. That's a requirement. We're going to run into tort law problems if we don't do that. We're going to have somebody mooning people out the window, if we don't have an adult in that room. So everybody's going to have a faculty advisor or some adult that's going to be supervising these student organizations. And it's not a problem under the First Amendment unless it's a religious group. And it's not a problem then either, because the person who is there can participate in everything except the religious activities. So if I were the supervisor for a religious organization, I'm a public school teacher, I'm supervising a religious student organization, that's perfectly fine. I'm there acting as a professional and I'm neutral. Let's say we're going to have a bake sale. I am baking cupcakes and all that sort of thing with them, but we have a prayer at the end of the meeting. I'm going to be there in a non-participatory capacity when they're engaged in religious activity. Now, what if I want to pray in my mind? Who knows, right? That's kind of my business, isn't it? But I probably don't want to do one of these, or something that's going to indicate that I've taken sides. And I just want to caution everybody, sometimes I'll try to use some levity or I'll joke a little bit just to get through the night, But this is very serious stuff, and it's serious for this reason. Particularly if you've never been a member of a minority religion, you don't understand what it's like to be a member of a minority religion in a place where everybody seems to go to the same church, and everybody thinks it's perfectly fine to intermingle the state function, which you pay for also as a taxpayer, with the religious function. And you start to feel like an outsider. Our First Amendment is about making sure there are not outsiders in our society, that everybody has the right to participate equally in that public school, regardless of their religious faith. And in fact, we go a step further. We protect people's free exercise of religion and require the institution to provide a reasonable accommodation for religious beliefs and expressions. So if somebody is a member of a religious faith that doesn't have the same holidays, well, why are public schools in Georgia closed on Christmas? Because nobody would be there on Christmas, right? It's a very practical reason. You get reimbursed from the state by how many students are in attendance, right? So you cannot have the school district open when nobody's there. It doesn't make any sense. So at least technically, our schools are not closed for Christian holidays. It's just a recognition that nobody in a state that's primarily Christian, nobody's going to be there on Christian holidays. But people that are not Christians have holidays too. So during Yom Kippur or Rosh Hashanah or any other religious holidays, what you need to do is make sure you're providing for a reasonable accommodation for persons who have other religious faiths. And that is that you give them an opportunity to make up a test, make up the work, and all that sort of thing. Same thing with employees. If you are a member of a religious denomination that is not, your calendar doesn't fit with the traditional calendar, you have a right to a reasonable accommodation. If we don't want to put anybody in the position where God has commanded, they sincerely believe that God has commanded them to do this, and the state is commanding them to do this. The state is going to give to the religious commandment, as long as they can reasonably do so. And that's a respect for free exercise of religion. I think that's a wonderful thing, and it keeps us from killing each other in this society. And it shows real respect for sincerely held religious belief. Let me ask you a question and test and see how you do. The Pledge of Allegiance. You're a public school teacher, and you've got a student who is not, well, everybody stand and say the pledge. And everybody stands and says the pledge. You got a student that's sitting back there like this. What do you do? I can tell you what a teacher in Florida just did. She went over there and physically took the guy's hand and put it over his heart and told him he was going to say the pledge. Anybody see a problem with that? Serious problem. Goes all the way back to 1943. In the middle of World War II, we had a U.S. Supreme Court that said, in this culture, we do not force patriotic exercise upon people. People will choose to be patriotic or they choose not to, but we do not coerce people into that. Say what you will about Adolf Hitler. He was a patriotic guy, and they saw that. And they were not going to have that in the United States. They were not going to see this sort of forced patriotism. In Hitler's Germany, if you didn't say Heil Hitler and make the proper salute at the right time, you could be in big trouble. It could be life-threatening trouble if you didn't comply with the patriotic requirement of the regime. Well, we don't do that in the United States, and that law goes all the way back to 1943. That teacher just got suspended. It's also very possible that the school district is facing a lawsuit because this is well-established law all the way back to 1943. I can tell you what happens all the time is that people think, I can't make them say the pledge, but I can make them stand. Not true either. And that is that in that case, when you look at it, the U.S. Supreme Court said you cannot force either by word or act people to express their belief in ideas. Now, what you can do is you could punish somebody for, let's say instead of the flag salute, they give the one finger salute. You can punish them for that. If they're disruptive, when everybody else under Georgia law is going to have an opportunity to say the pledge, if they're disruptive during that, you can punish them because they're violating your school code of conduct. But if somebody is peacefully sitting in their seat, they have a right to do so. Now, in this particular case, it was even more serious because this was not only a violation of their First Amendment rights concerning speech, but also their religious rights, because this student happened to be a Jehovah's Witness, and the teacher knew that. And Jehovah's Witnesses, I'm not a Jehovah's Witness, but my understanding, somebody help me if you are, but my understanding is they would view a flag salute as equivalent to idol worship. So this young man was being forced into an act of idol worship, which is a very serious thing in his religious faith. So the chances they're facing a lawsuit are pretty good. Uh-huh.
Just out of curiosity, what if a teacher wanted to exercise that right of not saying the pledge, and an administrator took issue with that and maybe suspended it?
I can tell you what I would do if it were me. I would express to the administrator my sincerely held belief about that, particularly if it's rooted in religion. Then if it's rooted in religion, the free exercise clause is going to give me a right to a reasonable accommodation. So if I'm a Jehovah's Witness, for example, maybe it's so, I don't know the particulars, but it might be okay for me to use a tape recorder. Or maybe the principal says it over the intercom with everybody. I just move to the back of the room and I don't say it. I'm not going to make a big deal about it, but the bottom line is here, you have rights too. Remember, the court says it can hardly be argued that either teachers or students shed their constitutional rights at the schoolhouse gate. You have rights also. You cannot be forced as a condition of public employment to say, particularly if it's a religious issue.
I have a question about
And then we'll get back there, Jim.
fights.
Good question.
And-
I know where you're going already.
Like at what points, I have a couple questions about it. One, say the students are much bigger than I am.
Mhm.
At what point is it my responsibility to intervene on possibly harming my behalf when I know that the student who's getting beat up is probably going to suffer much more
Okay.
before an officer gets there?
It's a great question, and it really falls under the category of tort law, but also professional ethics. And you have a duty to protect those children that are in your care as if they were your own children. So what would you do to protect your children? Well, you're going to do what a reasonable person would do under the circumstances, and depending on the circumstances, that defines what you do. Now, let me put that into action, how that works. Let's say that I see two kids fighting, all right? Stop it. That's a good place to start, right? Well, I want to give you a heads up here, too. Don't believe everything you hear on the street about what the law requires. In fact, this comes up all the time. And one night this came up in class, and before I could give an answer, somebody said, oh, I know the answer to that. My cousin's neighbor's sister is a lawyer, and they said you got to yell, stop, 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 3 times. It would be great if the law worked that way. I just pass you out this list of magical rules, and it'd be kind of like Hogwarts, you know, you get these magical spells, and you would comply with the law simply by saying the magic words. It doesn't work that way. What you have to do is what a reasonable person would do under the circumstances. But Yelling stop's a good place to start. It's just not where you stop. If I yell for them to stop and they stop, problem solved. What if I yell for them to stop? The reason I'm yelling for them to stop is because there's nobody going to get hurt from that, okay? I'm not going to get hurt, they're not going to get hurt. If they stop, it's all good. What if they don't stop? Now I got to decide what would a reasonable person do under these circumstances. Well, I'm almost 6 feet tall, and so I could I used to teach middle school and high school. I could safely get between 2 6th graders of reasonable size and probably separate them without either them getting hurt or without me getting hurt. What if I'm a high school teacher and those 2 kids are football players and they're like 6'6" plus? It's not getting killed is not reasonable. You know, and I don't get paid enough for that. So what do? I'm gonna dial 911. I'm gonna get a hold of the school resource officer, or I'm gonna get some of the administrators down there as soon as possible. I'm gonna keep yelling stop. And if this becomes a big problem, one of my former students teaches in a high school in the Atlanta metro area. He's got over 3,000 high school students, and he's actually very small physically, but he's got the world's loudest whistle. My ears are still ringing. He demonstrated it. And it just shocks people's consciousness. Even big guys a lot of times will stop when they hear that. So the bottom line is you have to do what a reasonable person would do under the circumstances. That does not mean endangering. You need to be careful you don't hurt the kids. If you're going to decide to intervene, do not use excessive force. You're actually off. What if this gets really serious? What if one of the students attacks you? You're authorized under Georgia law to use force that is reasonably necessary to protect you or somebody else. You don't have to stand there and let them beat you or harm you. You can defend yourself using force, but only using force that is reasonably necessary. And that is, I'm trying to protect myself. I'm trying to protect other people in the room from this person that's out of control. And we're calling for help in order to get back up in here as soon as we can. You also stop as soon as the threat stops. You know, if somebody's attacking me and I push them back out of self-defense and then they run away, I don't chase them down for vengeance, you know. Now, I might follow them in order to make sure they don't hurt anybody else, or in order, but I'm going to be real careful with that. You want to make sure you're not chasing somebody so they believe they're being chased and they like run into a busy street or something like that. So I can't tell you everything to do. I can tell you to use common sense. You want to think. And how do you make a good decision in the heat of battle like that? You think it through before it happens. And that's a really smart thing to do. Before you step into that classroom, you should think to yourself, what do I do if this happens? And we just talked about that. So now you kind of know. You've got this series of things. I'm going to do A. If that doesn't work, I'm going to do B. If that doesn't work, I'm going to use C. And I'm also going to make sure I have a means of contacting the school resource officer or the principal or whoever if I need backup. Does that make sense to you? And yeah, this gentleman, you told me your name, I can't remember. Zach had a question.
Yeah, if you're outside of class, like outside of the school in general, in relation to to drugs and like alcohol, if you happen to catch a minor downtown drinking,
Yeah.
Is that something you report?
I never saw it. No, I'm kidding. I'm not going to go looking for trouble, to be honest. I mean, this is a really interesting question that you ask, and that is, what are the limits of school authority? There's no question you have jurisdiction over their conduct when they're in the school. No question about that. But in order to punish them for conduct that is off campus, do you care if I raise this here? There's no question that you have jurisdiction. That is, let me work sometime. No question you have jurisdiction over things that are going to happen on campus. That is your business. You have not only do you have the authority, you have the legal duty to make sure they're not engaged in conduct that's harmful to them or inappropriate. Now, what if this thing's happening off campus, though, instead? Okay? If it's happening off campus, you don't have any legal authority unless you can establish a logical nexus. Lawyers like to use phrases like that, so they charge you $300 an hour. That just means a logical connection between this off-campus event and a significant negative impact upon the school. So if, like, for example, Zach, you're doing a great job as a teacher, but one of the things you're doing is you're enforcing discipline in your classroom, and somebody didn't like it. and they decide they're going to get even with you because they're going to wait at the Quickie Mart or whatever, because they know you go in there every day and get one of those big frozen drinks and a donut, you know. So you're very predictable. You're going to show up there right after school, and they're waiting for you when you come in. And they start cursing at you. What do? Well, if they were cursing at you in your classroom, no question you could do something about that. What if they're cursing at you in the 7-Eleven or whatever it is? They're cursing at you because of what happened here, right? And when they come back tomorrow, if they're not punished for this conduct, that's going to have a negative impact upon discipline within the school. You now have a logical nexus between this off-campus conduct. So the answer to your question is, if I'm going to try to punish somebody for something that happens off-campus, I'm going to have to show that I have a logical nexus, a logical connection between that activity and a sufficient negative impact upon the school. This is really coming up in these sort of cyberbullying cases and harassment online, because in the cyber world it's really difficult. There is no physical line between on-campus and off-campus, and the courts are still dealing with that one. I think the real question is, pick your battles, decide which ones you want. You know, I'm too busy to go around snooping and seeing what these kids, they're enough trouble during the day, right? I'm going to let their parents take that one. You know, their behavior when they're not in my classroom. If I think I can protect the health or safety of a child, I'm going to do what I can. I'm certain I can tell the parents. You know, there's no prohibition against that. If they're engaged in criminal activity, I can call the police. That's something I could do. I'm not, in general, going to go looking for trouble. I'm a little busy. Anything else?
What if they turn around on you? Like they've seen you get either downtown or they've seen you at a restaurant.
What am I doing?
If you are engaging in legal activity.
That's going to be a problem. They can call the police too. They can call my employer. But I'll tell you what's not illegal activity, although it's tricky in some communities, and that is that I have a legal right to drink beer. I'm over 21. So if I'm with my wife in a restaurant and I'm drinking wine or beer, I personally think that's my business. Now, there are some communities in which they're going to tell you that they're not really comfortable with you drinking wine or beer in their community. Whether they have the legal authority to do so, I think is very questionable. Now, whether they could non-renew your contract when you're not tenured, though, that is something they can do without reason. In fact, do we have time, Amy, to go over tenure really quick? Sure. Okay. Do we talk about, is that okay?
Can I ask first, what if
Yeah,
you're
please.
drunk?
I'm sorry?
What if instead of a couple of glasses of wine, you were out in a bar with a couple of buddies on a Friday night and you're intoxicated?
Well,
and a family or students come in,
yeah.
and y'all are laughing it up and having a great time, but you're certainly intoxicated.
It might be unprofessional conduct, particularly if I'm doing, I think again, we got the same problem here of the school administrators are going to have to show that there's a logical connection between my off-campus behavior and a sufficient negative impact upon the school. Now there is this general notion of the teacher as an exemplar, as a role model, and that hasn't gone away, but it's changed. You know, I've got in one of these books, I've got this set of rules from California school district in 1915, and they prohibit things like riding in a carriage with anyone who is, any male who is not your father. You know, and it tells you that if you're going to travel beyond the limits of the school district, you have to get the permission of the school board president, you know, before you can leave. It's a whole series of, you have to wear petticoats that are a certain length, and you have to get into the school district. They're really detailed. You have to be in there before 8 a.m. so you can turn on the heat and scrub the floors and all sorts of things. Well, it's changed a lot. The idea of exemplary, it's still there. I can tell you where the line is for sure. If you commit what would be a felony under Georgia law, that's a crime that's punishable by a year or more. The PSC can take your certificate, and then the school district can't employ you even if they want to at that point. If you take a look at the PSC Code of Conduct, they're going to go into a little more detail about what constitutes, a felony certainly constitutes a crime of moral turpitude. They're going to talk about some other things that do and do not constitute a crime of moral turpitude. The PSC does not consider, for example, public intoxication to be a crime of moral turpitude. But what am I doing when I'm intoxicated? I'll tell you one that would get me in trouble. If I'm making fun of students, I got a real problem. You know, I'm talking about how stupid my students are. There have been teachers that did this online. You guys heard about that? They'll go onto their Facebook page and start saying horrible things about their students. Bad idea. In fact, clean up your Facebook page. That's probably just a good idea. Well, let me talk with you about tenure real quick and how tenure works. It works like this under Georgia law. Erase. I'm trying to stay over here because there's a mic right there. Here's how tenure works under Georgia law. There are two types of contracts. There's a contract for a definite period of time, and that runs from, for example, the beginning of the school year to the end of the school year. And during this time period, this contract gives you a property right, and that is that you're entitled to X amount of dollars, and that is a valuable property right. You also have a liberty interest in your professional reputation. So if the school district is going to try to take either one of those away from you, they have to provide you with due process of law. That is notice of a valid reason for punishing you and an opportunity for you to be heard. Under Georgia law, there are 8 reasons that they can dismiss you, and the school district bears the burden of proving one of those. There are things like insubordination. That's refusing to follow a lawful order. Incompetency. That's not doing what a reasonable person would do professionally. And the last one is any other good and sufficient cause, which sounds big enough to drive a truck through, but it's got to be a good and sufficient cause. They can't just start making things up. So if they're going to dismiss you, even when you're not tenured, during the term of this contract, they're going to have to show a valid reason for that. That's usually not what they do, unless they can show a valid reason. You did something pretty bad. If they're not happy with you, what they do is at the end of this term, they simply non-renew your contract. And they're not going to give you an explanation for that. They're not required to give an explanation. In fact, any administrator that knows about due process of law is not going to give an explanation because in doing so, they may impinge upon a liberty interest. So that's why you have to be a little more careful when you're a non-tenured teacher because they do not have to give you an explanation for a non-renewal. They would have to give you an explanation for firing you before you've completed your contract, but they don't have to give you one for non-renewal. Well, what's tenure? Tenure is this kind of property right. It goes on indefinitely, and that is that you have a right to continue in employment in that school district until you decide you don't want to work there anymore, or the school district can prove one of 8 reasons under Georgia law. That's what tenure is, and it's an incredibly valuable property right, and it's important to make sure that we don't have politics in schools any more than we do, that instead it's a professional situation where people are retained on the basis of their professional performance and not based upon political reasons. So how do you get tenure? It's going to work like this. Your first year, you're going to come in there and you're going to get contract number 1, and you're going to go through this school year, and you're going to get a contract is formed by offer and acceptance. You're going to get a contract offered to you. If you decide to accept that contract, you've got contract number 2. And then you're going to finish out year number 1. Year number 2, you come back to that same school district, and you're going through here, and what happens is, actually, even if they don't have to give you an offer contract. If they just simply do not serve you with a notice of non-renewal, you're deemed to have been extended a contract. So if they don't give you a notice of non-renewal on or before April 15th, and you say on or before May 1st that you don't want it, now we got another contract, contract number 3. Now we're in year number 3. What's going to happen in year number 3 is if you have not received a notice of non-renewal on or before April 15th, you are deemed to be extended an offer which you may accept, and at this point, even less than the completion of 3 years. Upon the acceptance of your 4th contract, you are tenured under Georgia law. And that means that you have this right to continue employment in that school district. And that's at any school within that school district. Now, you don't have a right to a particular assignment. They can assign you to any assignment in that school district, but they can't reduce your salary by changing you to another position. Your salary is going to stay the same. And I would also tell you that now this is only tenure within that school district. Let's say that you decide you want to go to another school district. That's fine, but what you're going to do is you're going to walk away from your tenure in that school district, but it's not so bad because the Georgia General Assembly has said that if we have somebody who's been previously tenured in the state of Georgia, we're going to re-tenure that person upon the acceptance of the 2nd contract. So we have year number 1 in this new school district. You're going to walk in there without tenure, but on or before April 15th, If you've gotten a notice of non-renewal, you can accept that contract and now you're tenured in the new school district in less than a year. And that's how tenure works in the state of Georgia. It works slightly different in some other states. Every state gets to make up their own rules concerning tenure because it's a property right coming from that state. And I was tenured as a teacher in the state of Indiana. That doesn't mean anything to Georgia because my right was from the state of Indiana. So I would have had to start under this system with 3 years. I would not have been previously tenured in Georgia. That make sense? And that's how it works. I don't want to overstay my welcome. Is there anything else that I can answer for anybody? Yeah.
You were speaking about if you were intoxicated and you were.
Just to be clear, I was not.
You were saying that if you're intoxicated but you're talking about students, that's a problem, right? Or you're calling students.
Whether I'm intoxicated or not, one of the provisions under the PSC Code of Conduct, the Professional Standards Commission Code of Conduct, is that I'm supposed to maintain privacy. So if I'm talking about things like a student's disability out in public, where people can hear me name that student, if I'm talking about a student's disciplinary record, if I'm talking about their educational record, or if I'm simply being unprofessional, like making fun of a student or...
Well, what if you overhear that actually in school or directly in the classroom?
Teacher loud.
People have, anybody who holds a certificate from the PSC, what I want to refer you to specifically is take a look at that little, this thing right here, okay? And I can find it real quick, so I'll know exactly where to tell you to look. You're going to want to look at, well, rather do that. If you take a look at it, it's in the back there, and there's a provision in there concerning professional conduct, and that would be, it would be deemed unprofessional conduct to breach privacy or to say things that were inappropriate. And that's certainly true in public. It's true when it is clearly inappropriate, even among teachers. Now, if we're teachers and we're talking about a student that we have a mutual problem with, I can talk to you, another certificated teacher in my school district with the same student, because I'm talking to you about that student about a professional issue. Johnny is a real problem in my class. How do you deal with Johnny? But we're having a professional conversation about that. I'm not saying Johnny is an SOB.
Well, what if you do hear that type of talk?
It's unprofessional. Well, I would tell you that you have a duty under the PSC Code of Conduct to report unprofessional conduct. We're back to what Zach was talking about here earlier. How much, you guys ever seen Andy Griffith and Barney Fife? You know, there's an episode where Andy goes on vacation and he leaves Barney in charge, bad idea. He comes back and everybody's in jail. You know, even Aunt Bee and Opie are in jail. And so you don't want to be Barney Fife. You want to use some common sense in what you want to report to the PSC. But there is conduct. If I thought somebody was being abusive and really harming the reputation of a student, if it was really, really inappropriate, I am probably going to report that to the school administrator. Because I think the test here, would I want my child to be talked about like that? And if I think we do have to get people like that out of the school district if they're really, really unprofessional. We all get upset. Sometimes we vent a little bit, but we need to learn to do so in a professional manner. You know, Johnny is a real problem. Maybe I do think he's a real, you know, but I'm not going to say that. You know, I'm definitely not going to put in writing. People have done that too. Disciplinary reports. There have been people put profanities in disciplinary reports because they're angry. Don't put it in writing. I mean, it's pretty tough to deny it.
This one's short. What about a spouse? You're at home with your wife, in my case.
Well, under Georgia law, my wife cannot be forced to testify against me. That's one of the...
So if you, I asked this because this was a question.
I better be nice to her though, because if she decides she wants to, she can.
This is a question on the ethics test, actually, that they have. It's someone's home, they've spoken to their husband or wife about a child at school, the spouse realizes that they've worked with the person's parents. When that ends it, is that a violation of ethics that you've talked to your spouse?
I do not believe it is for this reason. I think it's not a good idea, but there is a marital exception to evidence. I think you're going to have a hard time proving it. But still, I don't mention names to my wife. If I happen to mention something, even about a student in higher education, and I'm not bound by the PSC Code of Conduct, I view that as a professional duty. I don't name students' names. sometimes I do have a bad day. I had a doctoral student, for example, giving me fits, you know, and just, you know, writing issues, you know, and then it's taking a long time, you know, but I don't mention the name because she didn't need to know that. What are you doing? What's taking so long? I told her, this is giving me fits. You know, I'm spending hours on this dissertation. You know, I wish she would act with a little more care, that sort of thing. I think that's all perfectly fine. Does that make sense?
Yes.
I want everybody to really understand this concept. The law is not black and white. It is only clear in the extremes. We do end up with a certain gray area in the middle in which what guides us is common sense. Anything else?
This is my last question, sorry.
That's okay.
You brought up Facebook. I have a teacher Twitter, and a lot of them follow me on their Twitters, which obviously are full of inappropriate content. I keep on being told by my mentor teacher, hey, just be careful, but I don't really know why. Like, I mean, I know I need to be careful, but I'm just wondering if there's any established laws at this point about, I mean, what could possibly get me, I mean, I'm not like, I'm tweeting about things like usually homework that's due that day, or things that were talked about in class, or if they're in ISS, they can check my Twitter for the YouTube videos that I showed, for instance.
Sure.
But what would be something I would be worried about?
All these social media things are becoming, and people are so used to using them, they're becoming integrated into people's daily lives. I've even got a Facebook page now, and I would have never guessed that. I'm basically Amish when it comes to technology. You know, but I've even got a Facebook page because almost everybody does. And they're always asking you, well, you know, what's your Facebook page, and et cetera, et cetera. I think that's a reality, that sort of thing. But I think you have to treat this virtual media with the same sort of respect that you would interpersonally. There's a real danger for people putting things in writing. You know, they're sitting at home all by themselves, and they're angry, and they put something down there, and it has the same, it's even worse than saying it in person, because you can't deny it. You're responsible for things that come out of your own account, no question about it. And there's no reasonable expectation of privacy when there's general public access to it. I'm not responsible for what other people say, though. Now, I might delete it. I've got 4 brothers, and let's say they put something inappropriate on my Facebook page. If I were to complain to my brothers, they would do it more. Right? That's the way it works. They don't care. You know, what am I going to do about it? I might delete it. You know, they don't do that actually. But if somebody does, I think you remove it in a reasonable amount of time. But I'm not responsible for what they did. Somebody wants to complain about that, here's their phone number. Call them. Yeah, I didn't do it. Well, here's what I want all of you to do. I want you to look at this as a start for you. A start learning about law and professional ethics. You've got some tools to start with. You've got this guide here that an electronic copy's been sent to you. You've got ways to learn more if you want to learn more, but look at it as a beginning, and I hope that you're going to continue to learn about this subject throughout your professional career. I can tell you from my own personal experience, it's really fascinating stuff. It's a lot of fun. I don't know whether I told you, whether I got to the punchline or not on this earlier. I was talking about Mary Beth Tinker. I spent Monday with Mary Beth Tinker. Did I tell you that or not? Yeah. I spent, over at the law school, I spent most of the day Monday with Mary Beth Tinker. And we're going to work on a special issue on free speech in higher education and also K-12. And so I'm continuing to learn about this stuff. I got to tell you, I think it's really interesting. It's a lot of fun. I hope you've enjoyed our discussion tonight. I know it's a long night. I'd love to start at 10 in the morning and not at 5 at night, you know, when you're not so tired. But I hope you've enjoyed the discussion and that it perks your interest in order to continue learning about this stuff. Because here's what I can promise you. Not only will it be more interesting the more you learn about it. It's like learning French, you know. Not very interesting when you're not very good at it. And when you get better at it, it can be fun. This is the same. But this has also got great professional and personal utility to you. You're going to sleep better at night knowing what the rules are. You're going to be a more effective professional knowing what the rules are. So I really want you to do yourself a favor and see this as a start of learning about law and professional ethics. And if we all focus more on this, we're going to have a more just society, we're going to have a more ethical society, and that's a good thing for all of us. Thank you for inviting me. I really enjoyed it.